Can a parties compromise a criminal offense or a civil wrong outside the court whenever they desire? Today in this video, I will be talking about law on compromise with respect to civil law and criminal law. Hi, I'm Mrs. Kritika Singh. It's been over a decade that I have been helping and supporting students to crack their Judicial Services Examination. So, the law on compromise with respect to criminal cases states that the general rule is that the criminal offences cannot be compromised at the wish of the parties, at the desire of the party, because the offence is not an offence against an individual only, but it is an offence against the entire society. So the entire society is affected by an offence. So the parties cannot compromise a criminal offence outside the court. But we do have an exception to it that is given under section 320 CRPC, the law with respect to compromise. The term used in criminal cases for compromise is compounding of an offence. So the word compound means compromise. The list given under section 320 CRPC gives us certain kind of offences which can be compromised outside the court with the permission of the court or maybe even without the permission of the court. But yes, the list given under 320 CRPC is exhaustive, meaning thereby जो भी offences 320 CRPC के अंदर दिए हैं, parties उन offences के अलावा कोई और offense खुद से compromise नहीं कर सकती हैं, खुद से compound नहीं कर सकती हैं. So even if you look into your Indian Penal Code Bare Act और classification में जहाँ पे nature of the offense दिया होता है, bailable, non-bailable, compoundable, non-compoundable. So wherever the term compoundable is mentioned, that means parties can compromise those offences under section 320 CRPC, but as an exception. On the other hand, if I talk about civil wrongs can be compromised at the desire of the party. The law with respect to compromise in cases of civil cases is given under Order 23, Rule 3. So whenever the party want to settle their dispute outside the court, if it is a civil wrong, they can settle their terms outside the court, and upon those terms, court will pass a decree, and that decree is called as a consent decree under Order 23, Rule 3. So the reason why parties can compromise their wrongs outside the court is because it is a wrong against an individual. It is only affecting an individual, not a society. If two parties have entered into a contract, so only those two parties are affected and only those parties ka locus standi hai. Apart from that, nobody is affected. So they both can, as per their own amicable terms, can compromise, and the court on those terms can pass a consent decree under Order 23 Rule 3. And Order 23 Rule 3 ये कहता है कि अगर एक compromise decree कोर्ट ने पास कर दी है तो आप subsequently दोबारा से उसी cause of action के ऊपर सूट फाइल नहीं कर सकते हैं. So यहाँ से preliminary examination में भी question आता है in Judicial Services Examination कि अगर एक कंसेंट डिक्री पास हो गई है तो उसी कॉज ऑफ एक्शन के ऊपर क्या हम सब्सिक्वेंट सूट फाइल कर सकते हैं, और अगर नहीं कर सकते हैं तो वो क्या रेस जुडिकाटा से बार्ड है या फिर ऑर्डर 23 रूल 3A से. सो द आंसर इज ऑर्डर 23 रूल 3A. सो फॉर मोर डिटेल ऑन कॉम्प्रोमाइज with respect to civil cases and criminal cases, I am coming up with a detailed video. Do subscribe on this channel for more insight on the law of compromise. Thank you for watching.